Good morning. This morning, we are going to discuss preventing workplace harassment and addressing inappropriate behavior. Our discussions and our discussion topics have become a little more HR specific, more relevant to the day-to-day and the topics and situations that you guys are encountering every day. So without further ado, let's get started. Now, before we begin, I'd like to remind you that we are not attorneys. This session is intended for education and informational purposes only. We do hope that you find these presentations helpful and informative, but the information presented today should not in any way be construed as legal advice. As always, if you have questions about how this information may affect your businesses specifically, we recommend that you consult with your business advisor. My name is Oscar, and I will be the one to host the discussion today. I am the Learning and Development Department Manager here at AHOLA. I've probably been with AHOLA for over 8 years, and I bring a total of 12 years of payroll experience. Please feel free to reach out to me by emailing omahia@ahola.com with any questions you may have regarding today's discussion. I'll be happy to work with you, your dedicated payroll specialist, or any other AHOLA team member to answer any questions you may have that's related to our system or services. Now, because this is a very HR-centric topic that we're discussing today, I would like to introduce the super intelligent and talented ladies that power our proactive team here at AHOLA. The team is the driving force behind such services like our applicant tracking support service, our proactive HR service, and our smaller proactive essential service, which is essentially HR consulting, and our compliance training sessions. Again, since harassment is a top HR related topic, and I am no HR professional, I will have Lori Geiger assist me in today's discussion. Lori is our HR consulting manager, and she will go over the bulk of today's presentation. Now, today we're going to walk through the full picture of workplace harassment, what it is, how to spot it, the laws that apply, and what to do if this happens. We will cover the reporting process, how cases are resolved, and how to recognize and prevent retaliation. We'll also talk about how investigations work and end with time for questions. If you have any questions, please feel free to utilize the chat function within the Teams meeting, and I will be monitoring that. And so the goal is to make sure everyone here knows their rights, understands procedures available to them, and feels confident in taking action if needed. So, since again, I am not the HR expert this morning, I'm going to let Lori take over and we will talk about what is harassment. Lori, thank you so much for joining me this morning.
Thank you, Oscar. Good morning, everybody. So I want to start the session today by defining exactly what we mean when we talk about workplace harassment. So harassment is defined as unwelcome behavior that's directed at a person or a group because of many things, including race, color, religion, national origin or ethnic origin, age, genetic makeup, disability, or sex. And when we say sex, we're including pregnancy, childbirth, sexual identity, or sexual orientation. So all of those people that I just referred to make up what we call a protected class. I'm sure that everybody has heard that term at some point in their career. Workplace harassment, it's important to note, can also be sexual in nature. Today, we are not going to focus on sexual harassment. However, many of the issues that we talk about in workplace harassment as a whole can apply to sexual harassment as well. So when we're talking about a harassment usually involves a pattern of behavior, so something that occurs repeatedly over time. It's a behavior that the victim is forced to go through day in and day out while they're at work. And when I say at work, I mean whether it can be in an office, whether somebody is remote, virtual, all of those considered being on the job. Harassment can also, on the other hand, involve just a single serious incident. For example, really threatening behavior or, unfortunately, actual physical violence. So as an employer, when somebody who's acting on behalf of an employer, whether you're HR or an office manager, anybody acting on behalf of the employer, directs any sort of harassing behavior at anyone in a protected class, it's considered a form of employment discrimination. And because of that, it is illegal. So if the harassment would come from a coworker, a customer, a client, or any other third party, it's still illegal when it targets someone in a protected class and the employer knew or should have known, as the law likes to state, about it. But there's failure to take quick and appropriate action to stop that harassment. So how do we identify harassment in the workplace? Harassment, a lot of times it's very blatant. So, for example, inappropriate jokes, slurs, labels, graffiti, any comments that might be considered derogatory, or any sort of threats. Often it can be really crude, insensitive, and just in plain sight to see or to hear. But that being said, not always. Sometimes workplace harassment can be subtle, and sometimes so subtle, in fact, that it might take a while to realize what's really going on. So, for example, when I say that, I mean that the harassment might take the form of underhanded comments, subtle intimidations, or language or types of behavior that might even seem to be meant to be just fun and just joking around, like teasing and nothing more. But behind that, there could be some really unpleasant attitudes that eventually will come out into more overt comments or overt behavior. So subtle in legal harassment can be based on discriminatory assumptions. So when I say that, for example, harassment based on gender could include derogatory comments, such as stating that, and I've heard this before personally, that a woman in a warehouse isn't strong enough to lift something and asking, well, do you want a man to do that work for you? So that's a really good example and something that, like I said, I've heard personally on more than one occasion. Harassment can be based on a protected class. So, like we said earlier, race, religion, gender, age, national origin, disability, sexual orientation. In that harassment, again, can include derogatory comments, use of stereotype assumptions, or other behavior that just demeans or targets somebody because of their characteristic. So, for when I say that, for example, it could involve, again, something like a racial slur, making fun of somebody's religious practice or religious affiliation, making sexist remarks like the warehouse worker I just mentioned, or using age-based stereotypes. I've seen that a lot in my work as well. And it's also important to note that harassment in the broadest sense can involve behavior that falls short of statutory discrimination. And what I mean by this is that some kinds of behavior might not technically be considered harassment in a court of law, but that does not mean that you as an employer or an employee, they should know that employers do not condone the kind of behavior in that organization. So again, just because the law doesn't consider it harassment doesn't mean that it isn't inappropriate and has no place in the workplace. So again, I sound like a broken record, but I like to repeat it. Rude comments, overly critical remarks, any ostracizing behavior that's not based on protected categories that we've talked about before, again, might not be illegal, but it will not be tolerated in the workplace. There's just no place for it. And offensive, insensitive, abusive behavior that's directed toward any employee, even if it's not defined as the illegal discrimination in the law's eyes, is professional and inappropriate. The employer, you being the employer on this call, or if you're an employee on this call, just know that employers expect all employees to treat one another with courtesy and respect at all times. Okay, so we've defined harassment, and I repeated myself a few times, and I may again, so forgive me for that. But I like to make sure that if someone misses it the first time, they're hearing it again. So having said what harassment is, it's important for us to talk about what harassment is not, because sometimes there are misconceptions. So harassment is not your occasional teasing. Yes, it can be disrespectful, it can be undesirable, but occasional teasing is not the same thing as the behavior that we've been describing so far. Generally, an offhand comment, something that might be said when somebody is angry, maybe they just have some careless regard for another person's feelings, that does not qualify as harassment either. So as an example, say a colleague would make a single comment that reflects a stereotype about a person's sexual orientation, let's say. Although the comment, yes, is insensitive, an isolated occurrence without the ongoing behavior generally does not meet the legal definition of harassment. Minor isolated incidents, I'll point out, are also generally not considered harassment, even if they are directed at somebody in a protected group. So an example of this would be if somebody once told a joke offensive to somebody in a religious group, a particular religious group, without having a history of saying these things in the past, it's unlikely that the law would consider that situation harassment because it's not ongoing. Again, this all to say, remember that harassment usually involves a pattern of behavior. So something that happens over and over, day in, day out. And again, employers, we do not approve of this type of behavior. And when it comes to our attention, we will respond as appropriate. So what is considered harassment? So we just talked about some of the circumstances that would not be considered illegal harassment. So now I want to kind of shift gears and talk about the circumstances that would be considered illegal harassment. So like the first block here says, one extremely serious incident. So that might be considered harassment if, for example, an employee was to be physically threatened by a coworker for racial, religious, or ethnic reasons. In this case, even if it occurred only once, an incident like this is so serious that it would have to be fully investigated. And if the complaint was found to be true, some sort of serious discipline, even up to termination, might result. Generally, however, like I have just said, harassment involves a pattern of behavior, and that pattern would create an intimidating, hostile, or even an offensive work environment for the target of the harassment. So, for example, constant abusive language every day directed at a person who, again, a person of color, particular religion, or ethnic background, is what a court might say is severe and pervasive. And because of the severe and pervasive determination by a court of law, it would be considered illegal harassment. Conduct on part of the supervisors or coworkers that unreasonably interferes with an employee's work performance is also considered illegal harassment if it's directed at somebody from a protected group. And when I say this, I mean, for example, if an employee is just so upset by continuous put downs or offensive language, that person cannot concentrate on the job that they're supposed to be doing. Or if that employee supervisor just completely turns a blind eye to the behavior, at that point, a court would very likely rule that illegal harassment has occurred. And again, I know it goes without saying, but as employers, we find this behavior as very reprehensible, no matter who the target is, whether it's from someone from a protected class or simply by like a law of decency. If somebody is not being decent, again, I said it before, just because it's not illegal does not mean that it is okay and that it is right. And action won't be taken. So employers' policies should always require professional conduct from all employees at all times. And harassment, also, it's important to point out that it can negatively affect an individual's employment opportunities. So when I say this, I mean, for example, if a minority was repeatedly denied promotions and told by his supervisor that, his kind shouldn't be expected to get ahead in the organization, something like that. Very egregious, and that would definitely be a form of illegal harassment. We will go through some examples here of when certain comments or behaviors actually cross the line into workplace harassment.
All right, so I'll take care of the examples that we have here. So the first example on this slide, we're dealing with Carly. Carly is a seasonal cashier at a garden supply store who has psoriatic arthritis, which makes standing for a prolonged period of time very painful. Carly's also 68 years old and significantly older than all of her coworkers. While the employer has a rule that prohibits cashiers from using fatigue standing mats or chairs while at the cash register, Carly has a reasonable accommodation under the Americans with Disabilities Act to use a mat or a chair as needed. Now, Carly's co-workers criticize her for getting special treatment, often stating that it's unfair that she gets to be more comfortable than them. They also hide Carly's mat and chair, which prevents her from starting shifts on time. Once, when Carly mixed up an order, a coworker yelled at her and asked if she was too old to get the orders right. So based on these facts, the coworker's harassing conduct towards Carly is based on disability as well as her age. This is also considered intersectional harassment, which happens when harassment is based on the intersection of two or more protected characteristics, which often compounds the harm. Another example here, we're going to work with Paula. Paula is 65 and a salesperson at a furniture store. Paula's supervisor, Simon, who is 52, has recently become critical of Paula. After Paula asks to use some personal leave, Simon denies Paula's request and states that this company needs some young blood and tells Paula that she needs to keep up with the millennial team or she needs to quit or be fired. After that, Simon stops referring to Paula by name and instead calls her old lady or Grams. Simon also refers to Paula as over the hill. Now, based on these facts, Simon's harassing conduct towards Paula is based on Paula's age, even though Simon is also within the same protected class, which is considered 40 or over, which is really egregious in my opinion. Another example, we're going to work with Alex. Now, Alex is frequently harassed by coworkers who believe he is gay, even though he's not. They make derogatory jokes, leave offensive notes at his workstation, and exclude him from team lunches. The harassment is based entirely on the perception of his sexual orientation. Harassment based on the perception that an individual is a member of a protected group, for example, the belief that a person is of a particular national origin, religion, or race is prohibited even if the perception is incorrect. In this case, even though Alex does not identify as gay, this behavior still constitutes harassment under workplace law because it's based on a protected category, which is sexual orientation. If harassing comments are based on a protected category like race, national origin, or disability, an employer is not shielded from liability for failure to address a hostile work environment just because the comments do not accurately describe the employee. We have another example here, harassment based on stereotype. Fatima, who is Muslim, is repeatedly told by coworkers that she must be oppressed because she wears an hijab. Others assume she doesn't celebrate U.S. holidays and exclude her from office events. These assumptions and exclusion, based on stereotypes about her religion, create a hostile environment and constitute harassment. Harassing conduct based on stereotypes can include racial epithets or offensive comments about members of a particular group. It also can include harassment based on traits or characteristics linked to an individual's race, religion, or ethnicity, such as the person's name, cultural dress, accent or manner of speech, and physical characteristics, which can include appearance standards like hair textures and hairstyles commonly associated with specific racial groups.
Thanks, Oscar, for giving my voice a break there for a minute. Thanks for going through all those examples for us. Some of those I'd like to point out, I've actually seen in one form or the other. So it's not just a made up situation for this webinar. We're pulling from personal experience here in HR. So just know that these things have happened to somebody in my experience. Just wanted to point that out to say how close to home it really is. Now I want to talk about the different types of harassment. So harassment can be verbal, it can be nonverbal, and in today's day and age, it can be virtual as well. So in the worst case, harassment can take the form of threats against an individual, and the threats might be explicit, they might be implied, and they don't actually have to be carried out to be considered harassment. So what I mean by that is intimidation is another form of harassment that can be expressed verbally. So it might be taking the form of bullying or put downs, both designed to make a person feel just scared or insecure of themselves. Verbal harassment could include things like offensive language, racial slurs, ethnic slurs, or any sort of derogatory comment that's directed at a person, again, because of race, color, religion, national and or ethnic origin. I mentioned graffiti in the past. Graffiti can be a form of harassment. I know it's something that we don't think of first and foremost a lot of times, but I like to include it because it does happen. Constant jokes about a person's race or ethnic origin can be considered harassment. Something like circulating insulting stories or rumors about a person sometimes happens too in the workplace, and that is considered a form of verbal harassment. So I want you guys to kind of reflect back to your own experiences and think if you've ever been witness to any of this or been a part of any of this. And if you have witnessed it or you have been the victim of any type of harassment like I just talked about or I'm about to talk about, it's very, very important to talk to your supervisor. Nonverbal harassment, let's shift to that. That includes actions and behaviors that are also demeaning, threatening, insulting. So, for example, continually staring at somebody in a threatening or intimidating manner, that could be considered nonverbal harassment. So, can standing over somebody or invading somebody's personal space in a threatening or intimidating manner. Um, Inappropriate comments, jokes, images that can constitute harassing behavior, even if they're not communicated face to face. So by this, I would mean email, through text message, posting on social media somewhere, any type of virtual platform. In this day and age, technology can really blur the line between where home life ends and work life begins and vice versa. So it's much easier for work time to spill into personal time. And it can be a lot less clear where the line between professional and private behavior should be. So because of this, I know everybody knows what memes are, and they're funny to send back and forth to coworkers. A lot of people think even after hours, and it's really important for employees and employers to understand that just because it's during off time does not mean that there aren't any rules and parameters around what can be sent, what should be sent, I should say. And in this day and age with electronic communication, it's almost always instantaneous, right? So it allows people to say or send things before they really can process what the results or consequences of their actions might be. And that distance that's created being online, I know that I've heard the word keyboard warrior before, and I think that it's appropriate here. That can give people a sense of just being less cautious and less considerate that they might be if they were face to face with somebody. So the rule of thumb is if it's inappropriate conduct or inappropriate like language or commentary in person, it transfers to any form of electronic media too, and it may constitute unlawful workplace harassment if it contributes to that hostile work environment that we've been talking about. Moving on to virtual, some inappropriate virtual conduct. I kind of got ahead of myself when I was talking about a meme earlier. Also, an offensive comment or joke about another employee's race made during a virtual meeting or posted into the group chats in Teams or in Zoom or any other platform like that. Offensive imagery that's visible in an employee's virtual background. So posters on the wall or that's the first thing that comes to mind. Anything that an employee can see when there's a Zoom call or any sort of virtual meeting, backgrounds need to be paid attention to, and sometimes they really aren't. An offensive comment about an employee's physical appearance that might be posted on social media, that would be considered a form of virtual harassment. So could photos, videos, that are sent via email or cell phone again. Like I said, like the memes and things that are so popular right now. So why is harassment a problem? I don't know that everybody is actually wondering why it's a problem, but I want to go over from an HR perspective why it's a problem. Ultimately, it ends up hurting everybody in the organization. So the victims, a lot of times they lose a sense of security, their dignity, and their confidence really takes a hit too. So I always tell everybody that I need to deal with in one of these types of investigations, just think how you would feel if you were subjected to this. Just for being a certain skin color or a certain religion or having a certain background. But then beyond the victims, it also affects witnesses. So in many times to harassing behaviors or harassment overall, there may be one or more witnesses that either hear about it, see it firsthand, might notice something on social media, and that can really make all employees across the board feel very uncomfortable at work. Again, imagine seeing that or hearing that and then having to walk into the workplace knowing that that's the culture that's in front of you. In cases where threats or physical attacks occur, that harassment becomes a safety issue. And people, rightly so, may feel unsafe just going into their job every day. And again, whether that means walking through office doors or just logging on to their email and a Teams call. Also important to point out, especially to all the employers on the call, employees might lose confidence in the management and leadership of the organization. And some might even start looking for work elsewhere. And that's the last thing that we want as employers, is for our employees to feel uncomfortable and not to have that trust and that open dialogue there. And we don't want anybody to leave for a reason such as this. And a lot of people don't think about this, but employees who are accused of the harassment, but it's unfound and they're later to be found innocent, they can definitely hurt and suffer. They can suffer a loss of reputation. They can suffer a loss of their credibility. And even if they're found guilty, they are going to suffer some sort of consequence because they are going to be disciplined in some sort, including termination in some cases. So all of this to say that everybody in an organization really loses when there are incidents of any type of workplace harassment. All right, so now I want to shift into harassment law. We've already said time and again that workplace harassment is illegal. And the federal law, which is Title VII of the Civil Rights Act of 1964, is what makes it unlawful to harass an employee because of their race, color, religion, sex, pregnancy, sexual orientation, gender identity, national origin. All those are listed in that law. Harassment is considered unlawful when having to endure offensive conduct becomes a condition of continued employment, or the conduct is severe and pervasive enough to create that hostile work environment or an abusive, intimidating work environment. The law protects individuals from harassment, not only from supervisors, but from coworkers. And like I mentioned earlier, sometimes even a third party, like a vendor or a client or a customer. I have seen that myself, and actually I have been a victim of that myself. So I can speak very clearly on that. And it's important to note that both actual and perceived membership in a protected group are covered. So somebody doesn't, like in Oscar's example earlier, that he went over, the gentleman who coworkers thought was gay, but he wasn't actually gay. That's a great example of what I just said. So again, both actual and perceived membership in a protected group are covered. So I mentioned federal law. State laws have certain requirements as well, and a lot of states actually include additional protected classes up and above what the federal government considers protected classes. Some examples of those are marital status, political affiliation, and military or veteran status even. State laws, it's important also to point out, often apply to smaller employees. So when I say smaller employees, I mean with workplaces that have as few as maybe 1 to 4 employees, compared to the federal minimum of 15 employees. So I would never want anybody to think, oh, there's not enough employees here for me to think that this is harassment. like I said, even though the federal government puts that line at 15, states really take this in their own hands in a lot of cases, and it extends to all employers, even with that 1 or 2 employees in there. Employer responsibility, I want to talk about that. I mentioned before, but employers have a legal duty to prevent and correct any sort of harassment once they know about it. Or even the law says once an employer should reasonably know that it's happening. So it's very, very important to keep a pulse on the organization as a supervisor, as an owner, as somebody who is a representative of the employer overall. So having clear policies, clear training, consistent training, and prompt investigations if something comes up are critical to be compliant under both the federal and the state laws for harassment. Also, very important to point out that retaliation against an employee who reports any type of harassment is also unlawful, and that falls under Title VII and most state laws. So I just mentioned harassment policies. So when an organization has a harassment policy, it needs to take a firm stand against any form of workplace harassment. So the policy should encourage the employees who feel that they're being harassed to be able to come forward and report the problem. The policy should also include a promise to respond promptly to each and every complaint, including a statement in that policy that complaints will be investigated and proven harassers will be disciplined. Policies need to ensure fair and professional treatment of all employees. And finally, it should promote a respectful work environment for everybody. I always encourage employees to be aware of what their organization's harassment policy is, and I always encourage employers to really have a very robust harassment policy and make sure that you communicate it to your employees and show them where they can find that, whether it's in a handbook or something like that. Now on to how to handle harassment. So harassment complaint procedures are designed to encourage victims, like I said, or those who witness or know about harassment even to come forward and report the incidents right away. And all complaints need to be taken seriously and they need to be investigated. What I always like to point out is that in harassment incidents, sometimes it is allowed to bypass the normal chain of command if that is necessary when it comes to reporting their harassment. So when I say that, what I mean is if an employee feels uncomfortable talking to their direct supervisor or manager about that problem, that employee can go to the person above their manager or supervisor, or if an organization has a human resources team, they can go to that team as well. This is allowed because in some cases, the supervisor or manager could be the one who is doing the actual harassing. So it wouldn't make sense for the employee to go to their harasser. And in some cases, I personally seen this, an employee has gone to a manager or a supervisor, and that manager or supervisor didn't do anything, didn't follow through with anything. So that employee has the right to have somebody help them. Hopefully, whether you're an employee, an employer, a witness, hopefully everybody on this call will never have to report a workplace harassment incident. But if you do have to deal with one, we want to make sure that you have it properly reported and properly documented. So I'm not sure how many on this call know the proper procedure for reporting harassment. So we're going to do a little review with some of the information that's needed to file a complaint, and then what can be expected during the investigation process. So we're going to go ahead and move on to talking about that next. All right, so the helpful information to include when making a complaint. Number of different things I have listed here. So the complainant's information, so the person making the complaint, whether it's the victim or the witness, that person's name, if they belong to a certain department, what their job title is, what their email address, contact phone number, if there's a preferred method of communication, whether it's email, phone, an in-person discussion, all those things should be documented. Also, the accused information needs to be included. So again, name, department, if that's applicable, their job title, any witness names, again, job title, department, things like that, so everybody's easy to locate. Also, in a complaint, we need a description of the harassment, including things like dates, times, locations even. And if there are multiple incidents, each one should be described separately. If there have been any complaints made previously, like I referenced in our last slide, those should be noted as well. So if manager so-and-so heard about a complaint on X date and no action was taken, very important to include that in the complaint. All right, so what happens after that complaint is made? So step one, you'll see, is the investigation. So we as employers need to determine whether a detailed fact-finding investigation is actually necessary. In some cases, it might not be. For example, harassers sometimes admit to the harassing behavior. And in that case, there'd be no need for an investigation, and the management team could proceed directly to taking the appropriate corrective action. If an investigation is necessary, it needs to be launched immediately and proceeded with as quickly as possible. And it's important to point out that employers really need to be careful to take time to examine all of the information presented and talk to all of the witnesses that are named. While the investigation is underway, it might be necessary to take steps to protect the victim to ensure that further harassment does not take place. So, for example, an employer might need to temporarily transfer the alleged harasser or even put that alleged harasser on a non-disciplinary leave of absence pending the conclusion of the investigation. And the investigators need to objectively gather and examine any relevant facts. Unbiased is very, very important here. And then based on the evidence, that investigator or investigators will determine whether harassment has actually occurred and then decide on appropriate action, including if it needs to be appropriate corrective action. Step two, here we have make a determination. So we need to make a determination whether harassment has actually occurred in violation of company policy. In some cases, it really might be impossible to say conclusively whether harassment has occurred because there's just simply not enough evidence. That does not mean that an employer can't take any action. Employers still are responsible to take preventative measures like training for the employee. Employers need to monitor the situation, make sure that harassment isn't going to occur in the future. And then once that determination is made, we're going to move to making a report about the incident and writing it and submitting it as an investigator to the top management to review. And then step three, inform all involved parties of the findings. It's very important to inform any party who's involved in the complaint. So victim, harasser, harassers, witnesses will be informed of the results of the investigation and action will be taken. And I do want to point out that the actual results of the investigation can be communicated with the victim and harassers. As far as the witnesses go, we just need to make a general statement that thank you for being a witness, and we have taken appropriate action, and we have followed through with the investigation. Thank you for your help. So a little bit difference there. Where cases of inappropriate behavior has occurred that falls short of that definition of illegal harassment, an employer needs to make sure that the employees involved understand that whatever behavior has happened will not be tolerated, even if it doesn't, again, fall into being against the law. An employer also needs to take steps to resolve the conflicts that are interfering with good working relationships between their employees. And then finally, employers need to correct the problem, right? This goes without saying. And sometimes this could mean that there is a termination or some other corrective action is taken. All right, let's talk about corrective action. So whenever an investigation determines that harassment has actually occurred in violation of whether it's a workplace policy and or the law, employers have to take immediate action again. So whatever action is taken, the law says it must not adversely affect the victim of the harassment. Remedial measures stop the harassment cold and ensure the person does not behave this way again. Very, very important that the behavior is not repeated. All right,
Right.
oh, sorry.
No, it's okay, Lori. Giving you another break while I'll talk about examples of corrective actions. So, whenever an investigation determines that harassment has occurred and there's a violation of workplace policy or law, you, the employer, must take immediate and appropriate corrective action. Whatever you decide, whatever action is taken, the law says that it must not adversely affect the victim of the harassment. Like Lori mentioned earlier, remedial measures must, however, stop the harasser cold and ensures that the person does not behave in that manner again. Now, depending on the seriousness of the offense, such measures could include an oral or written warning, a demotion, a transfer or reassignment of departments, even suspension. Um, the harassers could go through training or counseling to ensure that they understand the company policy and why the behavior was in violation in the first place. And of course, ongoing monitoring to make sure that the harassment has indeed stopped. Remember, the goal of the remedial measures is to repair the damage done by the misconduct. So such action could include an apology from the harasser, a restoration of leave time taken because of the event, removal of any negative evaluations in an employee's file that came from the harassment by a supervisor, reinstatement if the victim quit or lost a job in result of the harassment, monitoring the treatment of the employee to make sure that there's no retaliation by the harasser or others in the workplace because of the complaint, and correction of any other harm caused by the harassment. For example, compensation for any losses directly resulting from the harassment event. Finally, you, the employer, would or should follow up with both parties until they are convinced that the remedial measures have been effective and the problem has been completely resolved. One thing corrective action should never be is retaliatory. So we're going to talk about retaliation next.
Thanks for the break, Oscar. I know we're running a little short on time here, so I'm going to go through these a little bit faster than I have been. We are going to go ahead and send this information out to all of our registrants. So if you want to look back, just know that you'll have that opportunity. Again, employer retaliation, it is illegal And retaliation occurs when an employee engages in a protected activity. And if there is a cause and effect relationship between an employee's protected activity and the employer's adverse action, that could be determined to be unlawful retaliation. It's unlawful under federal and state regulations for supervisors or managers to retaliate against any employee or allow other employees to create a hostile atmosphere as an act of retaliation. So here we have some examples of protected activity. I'm not going to go through them all for time's sake, but things like filing a complaint or a lawsuit alleging discrimination, being a witness to an investigation, communicating with managers and supervisors about discrimination or harassment, participating in an investigation by answering questions, refusing to allow or follow rather company policy or practice that actually would result in discrimination. We don't think about that a lot, and so forth. Things of that nature.
All right. So examples of retaliatory actions, not going to go over all of them, but they're not limited to actions that are employment related, right? Or actions that affect the terms and conditions of employment. Retaliation may include any action by an employer that has a materially adverse effect on the terms of employment. Could include anything that would deter a reasonable person from engaging in protected activity. An action could be retaliatory for an employee in one circumstance and non-retaliatory for another employee. For example, if a work schedule change might have little adverse effect on many employees, but in the context of an employee with a school-age child or children, the schedule change might have a materially adverse effect and could be considered retaliatory. An employer can't fire, demote, harass, or otherwise retaliate against a person for engaging in protected activity, right? And the examples here of when the Equal Employment Opportunity Commission, or EEOC, found retaliation, right? And again, these are the examples listed here. For the sake of time, we're going to move forward, but anyone in attendance will receive a copy of these slides so that you have these examples to go off going forward.
Thanks, Oscar. So as an employer, what can you do? So there's a lot you can do to help prevent workplace harassment. So first of all, make sure as an employer, you've read and understand the organization that you work for's harassment policy and that you familiarize yourself with the complaint procedure. Very important for you to be well informed about what to do in the event of a problem, either as you being the employer, or even you personally experiencing harassment, or you maybe even being a witness to somebody else. So as an employer, we can deal with somebody else's experience, or the experience might be happening to us, right? So we kind of get it both ways. Secondly, monitor workplace conduct to make sure that everybody is always acting professionally and coworkers are treating each other with courtesy and respect. Third, speak up in support of the respectful workplace. It needs to be made clear to all workers that management disapproves of any type of offensive behavior that we've talked about here today. Again, whether it's actually illegal or somebody's just being rude and totally insensitive about a behavior that's directed at a coworker for any reason. Fourth, report incidents of harassment immediately. So even if somebody is not a victim, we still want to encourage victims to report the problem. We want witnesses to report the problem. So it takes a village here. And then finally, cooperate with harassment investigations. So if anybody has information about a harassment complaint, that needs to be shared with the employer. So employers, again, need to have that open door policy when it comes to harassment, and let employees know this is our policy, this is where you can find the policy, and here are our procedures if this happens to you personally or if you're a witness to it. All right, conducting workplace investigations. So things that need to occur before the investigation actually begins. Maintain confidentiality. So this can be hard sometimes. A lot of times witnesses or victims will want complete anonymity. It's always important as an employer to never promise that. Certain things are going to have to be revealed in order to get this investigation underway, right? So that being said, information should only be on a need-to-know basis. Again, don't promise absolute confidentiality, but don't overshare and don't let anybody have more information than what they need. Very important to point that out. Provide interim protections. So like we said before, we might need to take actions to protect a victim, depending on the severity. So again, that might mean moving the harasser to a different part of the building, or limiting cutting off really the interaction between the accuser and the accused. Very important to note that the person who is complaining should not be the one who is transferred or anything involuntarily, because that could be seen as retaliatory. So if the person making the complaint is involuntarily transferred, retaliatory. If they agree to it or they bring it up, a little bit different story, but you'll want to make sure that you document that. You really want to work with the person making the complaint to come up with an amenable solution. This is a really good time to consult an employment attorney that you may be working with before you make any decisions here, because you want to make sure that nothing can be construed as being retaliatory. And then the last thing, create an investigation plan. You need to have a plan in place before you start the process. All right, creating that investigation plan, a couple steps here. You want to define the scope and the objectives. Just remember, every complaint has potential to turn into a lawsuit, so conduct your investigations with that in mind, and document everything with that in mind. And then establish methods and a timeline. So you want to pick who's going to do the investigation, one or multiple people, develop your interview questions you're going to use, and consider where to conduct those interviews. A private place is always highly recommended. You don't want that that person to feel like that you're talking to as an investigator to feel like they're on a stage for anybody to see or hear. All right, and then really quick, what about interviewing in evidence gathering? So you want to make sure that you explain the process to everybody involved. I mentioned bias before. You really need to remain impartial as an investigator, and as management looking at an investigator's results. You want to identify any inconsistencies through people's experiences. Always make sure that witnesses and complainants document written documentation as soon as they possibly can, so it's fresh in their mind, and also consider somebody's credibility. writing and communicating that investigation report. I'm not going to go through all of these. I just want to say, make sure that that report outlines all of your findings, helps you to make a formal determination, and is listed on that report. List whether policies were violated, and then any recommendations for corrective action that's needed to address the complaint. And finally, implementing the corrective action and closing the investigation out. It's very, very important to follow through. So you want to implement any corrective actions that that report outlines. If the victim incurred any sort of losses, you're going to want to pull your legal counsel in at this time. Very, very important. Failure to remedy any damages incurred by the victim can lead to an EEOC complaint, or really legal proceedings. You want to make sure that you follow up with a complainant to make sure that they're comfortable, and make sure that you store that investigation document somewhere secure and private. Sorry, I rushed through that last one, guys. I wanted to get the information across. And then key points, my final words of the day to you guys. Thanks for hanging out. Illegal harassment, again, defined as unwelcome behavior directed at a person because of race, color, religion, national origin, or sex. Rude, insensitive, or abusive behavior should not be tolerated in any organization in any form, whether it's legal or not. And everybody, as an employer or the representative of an employer, plays an important role in helping to identify and prevent workplace harassment.
All right, a lot of information. Thank you so much, Lori, for sharing that with us this morning. And just remember, harassment, these situations, and the reason why we wanted to take the time and give you all of that information, not only is it a compliance issue, right? There's certain laws on the federal and state level that we have to adhere to, but it also affects the company culture, right? Culture plus being in compliance has a definite correlation to how successful your companies are, and that's what we're here to do. Again, Lori, thank you so much for all your information that you presented today. For any one of us in attendance that does not have a professional HR person at the workplace, or you need some HR assistance, you can reach out to me, reach out to Lori, as we do have HR consulting services like our Proactive HR and our Proactive Essential service. Any questions that you have regarding the information, we also have the chat box on this webinar. Feel free to enter that. Again, you can email one of us with any of the questions that you may have. If there are no questions, thank you so much for attending this important and informative webinar session, and enjoy the rest of your day. We hope to see you again on our next webinar. Thank you.
Thanks, everybody.